In this video, I want to talk about fault and negligence and liability and what that means and how it impacts the potential settlement value or trial value of someone's case. So, fault and negligence are sometimes used interchangeably. All negligence means is failure to act as a reasonable person would do. So, what would a normal, average person, if they're being reasonably careful, do? And if you fall short of that, that's sort of the standard definition of negligence. Legal claims for car accidents and other personal injury cases generally require proof of negligence. It's not enough that someone injures you. It's not enough that you get involved in a crash with someone else or you trip and fall on their property or something like that. It's not strict liability in most situations. It requires proof of fault, proof of negligence, that someone actually did something wrong. In driving, it's sort of obvious. Things like, driving too fast, not paying attention, missing stoplights and stop signs, things like that. Maybe not braking fast enough, following too closely. Things that, and a lot of times, the standard of care, what is required of people, is more or less set forth in the sort of the traffic laws, speed limits, and things like that. Although that doesn't always mean that as long as you're following the law, you're acting negligently. But usually, if you're speeding or breaking one of the laws, traffic laws, that's usually a strong indication that there's negligence or fault. But as I mentioned, sometimes there is no fault, even though someone is badly injured. For example, if you're driving by yourself and you fall asleep at the wheel and you roll your vehicle and you're badly injured, um, there's no claim to be brought because you yourself are the person at fault, and you typically can't sue yourself. Now, if you roll over your vehicle because you fall asleep and you have a passenger in the car and they're injured, then they would have a claim against you and your insurance company. There are situations where no one really did anything wrong. Let's say you're driving along and a deer runs out in front of you and you crash into it and people are injured. There's really no fault there because unless you should have been paying attention more and should have noticed the deer, usually they come out without warning, right? Sometimes people have medical emergencies. They pass out while they're driving, and unless they had reason to suspect it would happen, that's probably not negligence or fault. The emergency doctrine is something that can excuse what would otherwise be negligent conduct, such as if you're driving and a car pulls out in front of you and you instinctively jerk to the left or jerk to the right and you go into the other lane of traffic. Normally, you're not allowed to do that, but if you're sort of reacting to something that happens quickly in front of you, sometimes that can be a defense to negligence or fault. Now, sometimes you can have liability. So liability is if you're, let's say you're liable for someone else's conduct, for example, vicarious liability. Vicarious liability is a fancy word when, let's say, an employer is liable for their employees driving, even if the employer didn't do anything wrong. By virtue of hiring someone, putting them in one of your company vehicles, and having them drive around, you can become vicariously liable as the employer for their driving. Sponsorship liability. Some states, such as Wisconsin, make you legally liable as a parent for your child's driving when they have a probationary license. So, like from ages 16 and 17 until they hit 18, and then they're their own person. So, there can be automatic liability in some states, depending on what those states' rules are. You can also have joint and several liabilities. So you could have multiple parties that contributed to do something wrong. So let's say one car pulls out in front of you, and then another vehicle that's not paying attention pulls in front of you, and together they cause an injury. That can result in joint and several liability, or if there's multiple parties involved, there are certain situations where they can become jointly and severally responsible for each other's conduct. How does fault affect your claim? So the more at fault someone is, the more that you're going to recover from them. So sometimes when there's multiple actors involved, the jury will be asked to divide up fault between multiple people, sometimes including the plaintiff or the injured person. That's called comparative fault. I have another video that I'll explain that in a little more detail. In some states, if you are more than 50% at fault, you cannot recover at all. In some states, if you are at fault at all, we call that pure contributory negligence, you don't recover at all. So it really depends on the state that you're in to determine how fault may affect your claim.